Good morning and welcome to this session of the Kansas Court of Appeals. My name is Catherine Gardner and I will serve as the presiding judge today. And with me today, I'm happy to be sitting with Judge Tom Malone and Judge Angie Coble. We thank you, counsel, for your flexibility and changing things around at the last date and to meet remotely due to the weather. We have 6 cases today. Yours is set for 15 minutes and counsel for appellant, if you'd like rebuttal time, just let me know when you start, but I will call our first case this morning, which is 126306, the state of Kansas versus Freddie David Morna Espinoza. Counsel, your appearances, please, for the appellant.
Your Honor, may it please the court. My name is Kevin Zulator, representing Mr. Espinoza, appellant, and I would request 3 minutes of rebuttal time.
You may do that. Thank you.
May it please the court, the appellee, state of Kansas, appears by Stephen J. Obermeyer, Assistant Solicitor General, present and ready for argument.
Very good. Counsel for appellant, you may begin.
Thank you, Your Honors. I understand that this court has read the briefs, knows the facts, so I will jump right into the argument. If the court has questions, obviously I will address that. But the deputy in this case transformed this public safety stop into a criminal investigation when he asked for my client's ID to run that ID for wants and warrants. And because that is what he always does, even when he suspects there is no criminal activity, that is gross and flagrant misconduct.
Does it matter, Mr. Zolatar, does it really matter what he usually does?
Yes. That's part of the analysis, I believe, of gross and flagrant misconduct. That this wasn't something that happened once or it was just a mistake. This deputy always asks for ID to run it for wants and warrants. He always does it in criminal investigation, even when he suspects there's no crime, anytime he has interaction with the public. Specifically, State v. Ellis, the Kansas Supreme Court, has said after repeated admonitions that this cannot happen, it continues to happen. And so, yeah, I think it is very important that he does it every time. And I would like to just go ahead and point to State v. Ellis. That's 311 Can 925 at 939, because they talk about the officer in that case. And Mr. Obermeyer filed a 609 letter, and I think what he's trying to do is divorce this officer's subjective intent from his conduct. And in the Supreme Court case, what they wrote was Officer Kent in that case. The officer in that case openly conceded that the purpose of requesting her identification was to transform the check into a criminal investigation. The officer asked her for her driver's license, quote, so I could run it, so I could let my dispatch know who I was talking to, unquote.
Let me ask you then, are you arguing that the officer's subjective intent should control our analysis in this case?
In this case, it should. I don't know that it should control, but it should certainly play a factor. And it always does. And I don't understand how we act like it doesn't. Like there was a pat down. Why did you pat him down? Objection, irrelevant, right? It doesn't matter why he patted him down. Of course it matters why the officer patted him down. That's their subjective intent. And then the court looks at that and says, was it relevant? I patted him down for weapons. I patted him down because, well, I thought they were a good looking person. I mean, of course his subjective intent matters. I pulled him over because of his race. And then I got up there and I found marijuana, and, let's just say that happens. And I file a motion to suppress, and Mr. Obermeyer goes, yeah, but I watched the video and he didn't use his blinker. So regardless that he pulled him over because of his race, which he clearly can't do, I found a reason that he could have pulled him over. And so we're just going to let that slide. That's, I think, the difference between common mistakes and gross and flagrant misconduct. This Kansas Supreme Court has repeatedly said you cannot, as a matter of course, ask for ID to run for wants and warrants. And that's what this deputy said under oath that he does every time. And the state has never even taken the opportunity to condemn that conduct, to say, yeah, we understand he shouldn't have done that, but here's our argument. In fact, they almost support the conduct. They argue that this is almost okay, even though the Supreme Court has said over and over, this hasn't happened. I want to make sure that we get into, if I may, if you don't have any more questions, this is a safety stop. And I think this is very important because I think this is what I got into my reply brief. And the reason I think Mr. Obermeyer, one, requested oral argument, because I think he wants to, I think his word was clarify, but in the district court, and this is on page 8 of the state's brief, they acknowledge that the state and district court argued that this was a public safety stop, which transformed into an investigatory stop. Then on page 22, and by the way, that's what they argued in the district court. That is what the trial court found. She found this was a safety stop because that's a public safety stop because that's what they asked. Mr. Obermeyer argued on page 22 of his brief that Deputy Craig, in this case, was involved in a lawful public safety stop. There's no dispute whether they like it or not, and I don't think we should get into that and go that far, but this is a public safety stop. So the law that they've been citing in their brief that talks about consensual encounters and, you know, oh, the lights didn't really matter in this case, that is totally irrelevant. The state asked for this to be a public safety stop. I filed the motion to suppress. The case law is abundantly clear for decades. The burden is on the state to come forward to the court and say, you know, we didn't have a warrant. It's per se unreasonable. Here's why it's not. And what they argued to the trial court was this was a public safety stop. And the trial court found it was a public safety stop. And Mr. Obermeyer argues this was a public safety stop. And in a public safety stop, you cannot ask for an ID to run it for wants and warrants, just out of course. I mean, I think the case law is clear on that. And that is why I think the state, it's so important to them to try again, I use that word, divorce that subjective intent of what he was doing, why he asked for the ID, why they want to divorce that and say, well, we think he could have. But I don't think there's case law. This is one of the arguments I think we've had about interpretation of the law, the Gonzalez case and the Ellis case and some other cases. I don't think there's a case that says you can always ask for ID to run for wants and warrants in a public safety stop.
But if I can ask you about Ellis, it seems to me that what the court condemned in Ellis was not asking for the ID in a public safety stop, but retaining it without reasonable suspicion. Isn't that correct?
No, I don't read it that way. Again, that's why I started with again, it says that the officer conceded that the purpose of requesting her identification was to transform the check into a criminal investigation. The deputy in this case asked for that ID to run it, which is at the point where it turns into a criminal investigation. What is he doing at that point? He is now criminally investigating my client. There is no dispute about that. Now,
but it seems that you're asking us to ignore the fact that the deputy testified that immediately when he got her ID, he believed it to be false. What do we do with that fact in the reasonable suspicion analysis?
Nothing, because it comes after the illegal, after the moment this becomes illegal.
So you're just saying flat per se, no officer can ask for ID if their initial reason for a stop is public safety, correct?
No. And in fact, I say the exact opposite in my brief. I explain that there are situations in a public safety stop where I think an officer may be able to ask for ID because it is in line with or towards the target of that particular public safety stop. And there are some examples, I think, where the courts have talked about. I think the young lady it was a public safety stop and she needed medical attention. I think it might be appropriate to get ID in that situation to see who you're dealing with. Or you think they might be a subject of a kidnapping. These are all public safety stops where you might need ID. But there are public safety stops, such as the Gonzalez case, where the court clearly says you don't need identification in the target of this stop, which is a public safety stop. Your target is to help the person, and that is the thing. So yeah, Judge, I want to be sure. I'm not saying there's a blanket rule one way or the other. I'm saying the facts control. And in this case, the officer, and the judge made the specific finding that upon approach, the officer had no reasonable suspicion of a crime. The state never challenged that, so that's a finding that's before this court. So when this deputy asked for this ID, he has no reasonable suspicion of any crime. And he asked for it, and there's no question why he asked for it. Again, he asked for it so he could run it for wants and warrants. He asked for it so he could do a criminal investigation. And so it's that point in time that I think it turns criminal, which is what we are unlawful. And again, I point to the Ellis case because this is decades old law that you can't do that. And he's openly saying, I do it every time. I did it in this case. I asked for his ID because I want to run for wants and warrants, and he had no reasonable suspicion of a crime, no idea that a crime was happening. He just does that every time. And everyone, at least the trial court and the district attorney, keeps ignoring this gross and flagrant misconduct. I don't, and perhaps this court will again disagree with me. I hope you don't. I hope you can see exactly what it is. Mr. Obermeyer, in his brief, never addresses it, never says this should not have happened as a matter of course. However, here's my argument. What they say is, actually, to go on, I think, in part of their argument, to condone it. To say, you know what, you know, when you pull someone over, it's a dangerous situation. They talk about that in their brief, and that's true. But he didn't pull. This wasn't a traffic stop. This was a public safety stop. And the Supreme Court is very, very clear that when you are going to interact with the public under this premise, your conduct and your actions need to be targeted towards assisting, not a criminal investigation. And the first thing this deputy did, the first thing he did, it says, give me your ID so he could go run it for wants and warrants. And there is
So
no.
how do you, so counsel, I'm sorry, but how do you separate this so objectively? So say, same circumstances, the officer gets out of his car, walks up, and we're looking at objectively, all he does is say, can I see your ID, which under Ellis and Pullman is okay, right? We don't look at his subjective intent. He just says, hey, can I see your ID? At that point, it's a fake ID. I mean, how do we, from an objective standpoint, ignore the fact that that ID was fake?
Well, first, Your
How
Honor,
are we?
First, Your Honor, I don't think he could ask for the ID. He has no reason to ask for the ID. And I don't think that's what Ellis and Pullman stand for. There are situations where it is necessary or needed to ID someone in a public safety stop. This is not one of them. That's the Gonzalez case. I mean, if that were true, the Gonzalez case should have failed. And in Gonzalez, they said you asked for identification, and they said you can't do that. You need to, assist with the purpose. Tell them the gas. I think it was the gas lid that was open or something. You need to do that and let them on their way. That's not what he did. He asked for identification. He asked other questions, and they said you can't do that. You have to stay with the assist. And so, and I understand again this subjective versus objective analysis that courts give, but we can't act like we don't always get into subjective. I mean, how many times does the state rely on the officer's training and experience? Is this court going to say, can I now object and say I object? His training experience is irrelevant because we're not talking about what this officer knows. We're talking about an objective officer knows. I didn't know if every officer generally has that training experience, because if they don't, then this officer's training experience is no longer valid. I mean, the reason why certain officers do things is important to the analysis. Again, that's why I said earlier, I don't think it's controlling, but I think it's definitely a factor. And how is this court just going to, I guess I just phrased this, just ignore this deputy saying, I do this every time. He told you why he did it. So if he said, again, I'll go back to the example, I pulled this person over because of their race, and it turns out he had a legitimate purpose to pull him over, does that make it okay?
Counsel, you're getting into your rebuttal time, which you're welcome to do.
No, Your Honor, that's all I have. Thank you.
Thank you. Mr. Obermeyer, I think you're muted. You must be muted.
I hope that's better.
Yes, sir.
May it please the court, the state appears by Stephen Obermeyer. I believe my colleague and I have a basic disagreement over whether identification can be requested in a public safety stop, and also on whether the subjective intent of an officer controls. I did file a 609 letter citing State versus McCarter, and that dealt with a district court suppressing because of the officer's subjective intent to prolong the stop. And the court said, we look at this objectively. And regardless of what Deputy Craig's intent was in this case, or what his training was, he could objectively ask the driver of a vehicle stranded on the side of K-99 highway that is out of gas for identification. Certainly, if a sick person in a Casey's in Emporia can be asked for identification, a motorist who's driving his brother's car and who, as it turns out, has a gun with a bullet in the chamber under the car seat, the officer can ask for the name of the driver. And the minute that the driver, the defendant, handed the Mexico driver's license stating that the defendant resided in Cleveland, Mississippi, that went from a public safety stop to an articulable suspicion to investigate whether the license was fraudulent.
Let me back up a bit because you implied it, but I'm not sure you addressed why you're saying it would always be legal under this type of circumstance to ask for an identification.
Well, in the Ellis case, where we have somebody in a Casey's store, the officer Kent proceeded to ask Ellis for identification. The court said this was also lawful. The court has held a law enforcement officer's mere request for identification or identifying information generally will not constitute a seizure. So I think the officer could do that. And the other factor is we're talking about the driver of the vehicle. And if this was going to, if this was going to be transporting the driver to a gas station or something, it'd be be nice to know the name of the person who has no gas, has no money to pay for gas. And if this were a AAA officer, AAA coming to give gas, I would think it'd be reasonable to ask for the name of the motorist. So I think the district court's ruling, which is set out in the blue brief, got it right, that there's a huge distinction between detaining an individual who can quickly fix a tire and a vehicle that by nature has run out of gas. There appears to be no gas by the car, and the person cannot leave in the car even if they want to. And once the false license was handed over, the apparent detention turned investigatory in nature, and I think that the district judge made the correct ruling on denying the motion to suppress. And the judge acknowledged Ellis and said, if the identification appeared to be consistent and valid, the further running of that information for wants and warrants is clearly a bright line rule of flagrant official misconduct. And that's at volume 4, pages 15 to 18. And I think my colleague wants to put the subjective intent cart before the articulable suspicion horse in this case. And you can't, I don't think you can do that, regardless of what the intent was. In the brief, I went through the 3 factors from Ellis. There was a legitimate reason to pull up behind the car, and it wasn't just for the safety of the occupants of that car. Remember, this car is straddling the fog line of K-99 on a 2-lane highway with no shoulder, and the officer had his lights on to alert oncoming motorists. And to say the officer just had to leave at that point, I don't think would be good police practice. And the officer had a right to be there. They had a right to call for a drug dog and have the drug dog circle the car, and it alerted, which was what prompted all this. There was nothing discovered from the license that led to a warrant. A lot of these cases have an outstanding warrant and then the person's arrested and they have drugs in their purse or car. That's not the case in this case. The reason for the arrest was the drug dog circling the car, and the defendant has not challenged that. And the officer had a right to be there, and it wasn't on private property where the defendant had a Fourth Amendment expectation of privacy in K-99 highway. So that is kind of goes to my point that there's no nexus between the running of the driver's license and the claimed illegal seizure of evidence. There was no warrant. There was no arrest based on the warrant. There is no fruit of the poisonous tree. And even concerning the flagrant misconduct argument, that the Ellis case says that our case law stands firmly against police detaining citizens and seizing their licenses when there is no indication these citizens have engaged in criminal conduct. And certainly the fake ID was an indication of criminal conduct that the officer could investigate and determine whether this person was licensed to drive. And as it turned out, none of the three people associated with that car were licensed to drive. Would it be reasonable for the officer just to let them go on their way? No questions asked, just, have fun here in Greenwood County. I don't think so. I think objectively looking at the officer's behavior, that was reasonable. And there was no indication that the defendant was forced to turn over his license. He did not testify. He did not testify that he believed he was illegally detained. In fact, I'm not sure there is any evidence that he was illegally detained. He couldn't drive off in the vehicle. He didn't try to walk away. I'm not sure what, if any, of his rights were violated.
Counsel, are you saying that if an officer during an encounter asks for a person's driver's license and the person turns it over to the officer, that's a voluntary action?
Well, it was in State versus Pullman, which the court cited in State versus Ellis, that when the officer in Ellis asked Ellis for identification, this was also lawful. This court has held a law enforcement officer's mere request for identification or identifying information will not constitute a seizure. And I think when you're the driver of the car, you can be expected to have to turn over your.
Well, all right, but maybe you didn't understand my question. When the officer asked for the defendant's driver's license, what if the defendant had just said, "No, I'm not giving it to you"?
If the defendant had said that, then the officer could ask for what his name was, because I think one of the passengers didn't have his license. He asked for the name, and I guess if he said, "I'm not going to tell you my name," I think there's a U.S. Supreme Court case that says a person can be, provide their name, but I think in the blue brief, I cited a State versus Heron where the defendant had given a false name, didn't have a license. So
I'm just trying to nail down. I'm not arguing with you. The officer had the right to ask for an ID. Let's presume that.
Okay.
But then when the defendant turned over his driver's license, are you categorizing that as a voluntary act?
I think that's what happened in Ellis and in Pullman, that he turned it over. That certainly wasn't. I don't think that was raised in the motion to suppress, that he was forced to turn over his license. I think their argument was that the taking of the license and running of the record was what constituted the violation. But I think in this case, he's the driver of a vehicle. Drivers are supposed to show their ability to be licensed to drive, and that would be reasonable in that situation. But it's really not the scenario, because he did turn that over. I hope I answered that question.
Yeah, that's good. That's fine.
Okay. I think I covered all the points that I wanted to make, that you can ask for ID in a public safety stop. And once, if you deliver a false ID, that can be investigated. And that we look at this objectively, and the fact that at some point, well, the fact that there was a false license was kind of an intervening circumstance, so we don't get to the flagrant misconduct because of that. And I think if you look at the district court's ruling, that the court was aware of the distinction between Ellis in this case, and that the district court's ruling should be affirmed.
Thank you. Appellant, you have 3 minutes.
Thank you. Mr. Obermeyer just said, basically, the driver of a vehicle needs to be ready to show that I think that they have the right to drive. That is just not true. Not in a public safety stop. The courts have consistently said that is not true. It's categorically not true. If the police decide to interact with the public during a public safety stop, they are not allowed to investigate. They are not allowed to make sure this person is legally driving. Mr. Obermeyer talked about, well, they later found a gun. I don't know what relevance that has, other than to make sure this court knows that, if you grant it and suppress it, that bad evidence is going to get thrown out. They didn't have any indicia of criminal activity. This deputy did not when he asked for the ID. So really it comes down to, I think, what this court is centering on is, can you just ask for an ID as a matter of course whenever you have contact with the public?
But don't we then want to look at the facts that, the car did pose somewhat of a hazard, being parked where it was on the white line. They were out of gas, and to remedy that problem, which is what you would do in a public safety stop, the trooper or the deputy either had to take them in his car to get gas, or to wait there with them until a tow truck came. So is his safety not a good reason to ask for ID?
No, it's not. I mean, the case law is clear on that. There is no law that says the officer is putting himself in that situation by stopping somebody, seizing them when he has no basis to believe there's criminal activity. And when he does that, he can't create that situation and then say, oh, now I need your ID. Now I need a criminal investigation, because it is a public safety stop. It is not a terrorist stop. There's no reasonable suspicion of a crime. It's not a traffic stop. All of those I get are officer safety concerns. He's initiating this stop, and I don't think the Supreme Court can be more clear. They continually say you cannot do this.
And I guess that sort of goes to Judge Malone's question. Would you say when the officer in this case asked for ID that started a seizure at that moment?
He was already seized. That's already been found. This is a public safety stop.
Oh, you're saying a public safety stop is per se a seizure even before you get the ID of a person?
Absolutely it is. The case law says that. There's, I think, the case law says there's 4 types of seizures: voluntary encounters, public safety stops, and, I think the traffic stops or whatever. It is a seizure. But even if you don't want to find that it's a seizure initially, yes, because he asked for the ID. Why is he asking for the ID? Of course, this court, now, I guess you can't ask that question. So in your opinion, you can't say why he asked for the ID, because it doesn't matter. Because the subjective intent is totally irrelevant. Why did the officer pull up to him? What he saw doesn't matter. All of his testimony should just be stricken. You should just watch the video, which there isn't any, and then make the decision, because the state's position is the fact that this deputy asked for this ID so he could run for wanted warrants, got lucky that he found something suspicious on that ID, saves the day for him. That's what they're saying. That's the argument. So this officer has no incentive to stop doing that, because he's either going to find something or he's not. And if he finds something, Mr. Obermeyer is going to come in here and say, well, he found something. And if he doesn't, there's not going to be anything to do.
If you want to take a moment, your time is up, sir.
Okay. The Supreme Court has repeatedly said that this is gross and flagrant misconduct. I hope the court doesn't divorce that. What the officer did when he asked for it, he was started a criminal investigation. And also, we didn't really touch on it, but I hope the court reviews carefully the arguments we made in our reply brief about all the issues the state has raised for the first time on appeal. The state has not identified those issues as being raised for the first time on appeal, argued why they can make it for the first time on appeal. They've just subtly done that. They've made these arguments regarding consensual encounters, and this was a public safety stop. It was a public safety stop, not a voluntary encounter. Thank you.
Thank you to both counsel. We will take this case under advisement and get you an opinion in written form as soon as we can. Thank you.